Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters, whatever your questions are. Please feel free to get in touch. You can get in touch by ringing on the number that appears on the bottom of the screen. Alternatively, you can send us a message, a WhatsApp message, text message on the mobile number which appears at the bottom of the screen. Now, every week we get loads of questions on immigration law, which is fantastic. But even if your questions relate to other English legal matters, please do feel free to get in touch with us. A couple of very minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from viewers who call in. Sometimes your matters are complex and I need to take very detailed information from you before I can advise you. Now, if it transpires that your matter is complex, I'll ask you to leave your number with the control room and I will have a more thorough discussion with you off air. Secondly, sometimes I need to look at your documents before I can advise you properly. Sometimes you might have a refusal letter. In an employment matter, you might have a dismissal letter. So it's better for me to advise you after having seen your documents. Obviously, it's difficult to do that live on air. Now, if it's the case that I do need to look at your documents, again, I'll ask you to leave your number with the control room and we'll have a discussion after I've had a look at your documents. So that's the introductions out of the way. If you want to get in touch, please do call on the landline number. And by all means, if the matter is a bit confidential, you don't want to come live on air, please get in touch with us on the mobile number. Okay, let's take our first call for the day. Hello, assalamu alaikum.
वालेकुम सलाम। अलियास भाई, हमारे दो क्वेश्चन हैं
जी। ओके।
एक तो यह है कि वर्क परमिट का क्या तरीक़ेकार है पाकिस्तान से आदमी इधर मंगवाना हो तो।
ओके ओके।
तो एक मेरा दूसरा क्वेश्चन ये है कि एक मेरा भाई है, उसका एक बच्चा भी है, ब्रिटिश उसकी वाइफ है, ठीक है। क्या कि वो अभी केस डाल सकता है या नहीं डाल सकता? ये मेरे दो क्वेश्चन है, प्लीज इस बारे में मुझे।
आपने जो वर्क परमिट के बारे में जो बात की ना, तो
जी पहला सवाल वर्क परमिट।
जी, वर्क परमिट। यहाँ कोई बिजनेस है जो वर्क परमिट पे ये बंदे को बुलाने के लिए तैयार है? कोई जॉब उसके पास है, कोई स्किल्ड वर्क, ऐसा कुछ है यहाँ? कोई आपने तैयारी की?
ओके जी।
यहाँ कोई बिजनेस है, फैक्ट्री है, ऐसा कुछ है?
एक दोस्त है तो वो यानी स्पॉन्सर करेगा ना।
ऑलराइट है, ओके। थैंक यू भाई आपका क्वेश्चन के लिए। आप प्रोग्राम को सुनते रहो, इंशाल्लाह मैं आपको जवाब देता हूँ। थैंक यू वेरी मच।
थैंक यू वेरी मच
indeed. So the caller has basically two questions that is put to us in Urdu. I'll just translate the questions first of all, and then I'll give an answer in English and then shortly in Urdu as well. The first questions relates to what the system we have for work permits. Very common questions at the moment. A lot of businesses are applying for sponsorship licenses with a view to sponsoring people on a work permit, which is known as the skilled worker visa at the moment. So that's the first question. The second question relates to somebody who's an overstayer in the United Kingdom, has a British partner, and as I understood it, has a British child. Now, in the circumstances, what can this person do who has currently overstayed their visa? Now, let me deal with the second question first, because I do want to deal with the work permit issue in a bit of detail. The second issue relating to somebody who's actually overstayed in the United Kingdom, but has a partner who is British and has a child from the relationship that would be British as well. What's the position with somebody who's in that situation? Well, the basic position is this, that the practice of the Home Office is this, that where you have a child who is British in the United Kingdom, and in terms of the relationship with the child, you are the person who's overstayed in the UK. You are either living with the child, so obviously you're residing with the child and doing everything that would be done as a parent, or if you're not residing with the child, you have regular contact with the child. So it may be that you've got weekly contact, or you've got fortnightly contact, whatever it is, as long as you've got actual contact, direct contact with the child, you are able to apply for leave to remain on that basis. So you either need to be living with your child who's British, or you need to, if you're not all living together as a family, you need to be having contact with the child on a regular basis. Now, as long as that's taking place, it is possible for you to apply for leave to remain in the United Kingdom. In practice, and this is what I've noticed, it doesn't matter if you're not married to the British citizen partner, it doesn't matter if you've separated, none of that matters. It doesn't matter if you've overstayed in the United Kingdom for a long period of time. As long as there is a child from the relationship and the child is British, you are either living with the child or you have contact with the child, you are able to apply for leave to remain in the United Kingdom. And in my experience, I would say there is a very, very high chance of the application being granted. There are very limited circumstances in which such applications are refused. And even if the application is refused, and I have to stress that it is extremely rare for such an application to be refused. Even if it is refused, it is possible to appeal against that decision and let the tribunal judge make a decision on your application, on your appeal. So in one sense, it's quite good news if those are your circumstances. Now, because the caller asked the question in Urdu, let me very briefly answer the question in Urdu, then I'll go back to the first question, which is slightly more complex, relating to work permits or skilled worker visa. So भाईजान जो आपने पूछा था ये क्वेश्चन जो बंदे ने ओवरस्टे किया है, तो उसका सिचुएशन ये है कि अगर उसके पास चाइल्ड है वो रिलेशनशिप में से और वो चाइल्ड ब्रिटिश है और उसके साथ वो रहता है या तो उसके साथ कॉन्टैक्ट में है चाइल्ड के साथ, तो उस बेसिस पे वो वीज़ा के लिए अप्लाई कर सकता है और उसके पास वेरी गुड चांस है कि होम ऑफिस उसको वीज़ा दे देंगे वो ब्रिटिश चाइल्ड के बेसिस पे। वो देखते हैं कि चाइल्ड के साथ एज अ फैमिली आप रहते हैं या तो चाइल्ड से आप वीकली 2 वीकली मिल रहे हैं। तो अगर ये आपका सर्कमस्टांसेस है और आप ये बाय डॉक्यूमेंट्री एविडेंस उसको प्रूव कर सकते हैं, तो देयर इज़ अ वेरी हाई चांस कि आपका वीज़ा का एप्लीकेशन सक्सेसफुल हो जाएगा। ओके, सो दैट्स दैट second question out of the way relating to somebody who's overstayed in the United Kingdom but has a child that is British. The more complex question really is the question relating to the work permit scheme, or should I say in relation to the skilled worker scheme. It used to be called work permits, then rebranded, and then it was called the Tier 2 work permit, Tier 2 scheme, then rebranded again and currently called the skilled worker scheme. In essence, it's the same. Work permit, Tier 2, and now known as skilled worker visas. In essence, it's all the same. Obviously, over time, the rules have been amended slightly, they've been tightened, made more flexible, etc. But the essence of the scheme is the same, that you essentially have a business in the United Kingdom, a sponsor in the United Kingdom, and the sponsor is wanting to sponsor a migrant to come to the United Kingdom and work for them in the United Kingdom. So let me give you an example. There is, for example, a bed factory here in the United Kingdom, employs, let's say, for example, 50 members of staff, and they want to employ foreign workers. For example, the job may be a skilled job, such as a carpenter, designing bed frames, etc. It might be somebody who wants, who will be doing marketing work, business development work. It could be somebody who's going to be running accounts within the office. So a whole range of skilled work, from maybe professional level work to skilled work. But the factory, as an example, we're using a bed factory. Let's say they want to employ somebody from abroad. The key step is, first of all, for the business that needs to be registered with the Home Office. They need to obtain a sponsor license. once they've obtained a sponsor license, it's going to be possible to sponsor somebody to come to the United Kingdom to work for them. The requirement really is that the job that this person will be coming to do has to be skilled work. Now, it used to be before, under the old Tier 2 work permit scheme, that the skilled work has to be quite high level. So it had to be professional level work. So you'd find that only doctors, engineers, accountants, nurses qualified under the old scheme. However, now it's much easier because the skill level has dropped. Now, currently, the skill level is at A-level standard. So somebody who's a professional carpenter, they would be able to apply. Somebody who's doing other skilled upholstery work in this particular factory would be able to apply. So the starting point is the business needs to obtain a license, and they must be looking at filling a skilled vacancy. So it can't be a very, very basic job. It's got to be skilled work that the person that they want from abroad would be coming to do. The final point is that the person who's coming to the UK to work would have to pass an English test. The test that they do is an IELTS test, and the band that they need to reach is band 4. So it's quite a reasonable standard of English that they would need if they were coming to the UK. So essentially, it's broken down into 3 things. The business needs to obtain a license. The work that needs to be done has to be skilled work. So that's the vacancy that you want to fill with the foreign migrant. And the person who's coming to the UK must have a reasonable command of English. There's a particular test that they would be doing. Now, if you've got these things in place, there is the potential to sponsor somebody to come to the United Kingdom under this new skilled worker category. Hope that answers the question. We're taking a short break. We'll be back in the next couple of minutes. So inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To contact us, please do call on the landline number which appears at the bottom of the screen. We've got a caller on the phone, so let's go to our next call. Hello, Assalamu alaikum.
अस्सलाम वालेकुम।
जी वालेकुम सलाम। जी भाई, thank you for calling.
सर मेरा 2 सवाल थे।
जी।
मैं एक सवाल तो ये था कि मैं जो है ना मेरा जो केस था साइलम का ना, उसमें जज ने जब रिफ्यूज़ किया तो जज ने ये लिखा कि मैं जो यूके की इमिग्रेशन पॉलिसी है ना, इमिग्रेंट्स को कंट्रोल करने की,
जी
तो वो मैं उसके हक में हूँ कि यानी कि ये अच्छी पॉलिसी है और इमिग्रेंट्स को कंट्रोल करना चाहिए यहाँ पे। तो क्या जज इस तरह के कॉमर्स लिख सकता है अपने रिफ्यूजल में?
तो
और दूसरा सवाल था कि
जो आपका जो असाइलम का
वो हॉलैंड में
जी
आई थी, मेरे ब्रदर ने बुलाई थी EU सेटलमेंट स्कीम के तहत।
जी
इस तरह का कुछ था, आई थिंक कोई लॉ।
ओके।
वो वहाँ पे उन्होंने बुलाया तो उन्होंने क्या किया कि पहले वीज़ा रिफ्यूज़ कर दिया मेरी सिस्टर का, और फिर उन्होंने हेयरिंग के 1 दिन पहले उन्होंने कहा हमको, हमारे सोलिसिटर को लेटर लिखा कि आप विड्रॉ कर लो, हम आपको वीज़ा देते हैं। ठीक है, यानी वीज़ा कंसीडर करने केस। तो हमारे जो सोलिसिटर ने विड्रॉ कर लिया कोर्ट से केस। तो फिर होम ऑफिस ने क्या किया कि हमें लेटर लिखा 2 से 3 वीक के अंदर अंदर कि आप अपना केस जमा कराएं। तो वो अभी केस जमा कराया हुआ है कि सिर्फ वीज़ा, यानी कि उन्होंने ऑलरेडी होम ऑफिस ने जब कंसीडर कर लिया तो वीज़ा तो उन्होंने इशू कर लिया। उन्होंने 5 माह हो गए और हॉलैंड में, और मेरा भाई भी वहाँ पे यानी कि वो एक्स्ट्रा रेंट पे कर रहा है या वहाँ पे रह रहा है सिस्टर को यहाँ पे लाने के लिए। तो वीज़ा भी इशू हुआ, लेकिन वो होम ऑफिस वाले वीज़ा नहीं दे रहे। 5 माह हो गए, ठीक है, केस जमा करवाए हुए, पासपोर्ट जमा कराए हुए।
तो आपका भाई जो है ना, तो उसको किसने यूके में कौन है जिसने उसको स्पॉन्सर किया?
सॉरी मैं समझा।
जो आपका भाई है ना, वो कहाँ है? हॉलैंड में है?
हॉलैंड में है ना, वो बेसिकली ब्रिटिश है, लेकिन वो अभी हॉलैंड क्या हुआ है।
वो जो हॉलैंड में है, मगर वो ब्रिटिश में है। तो वो
सिस्टर का वीज़ा रिफ्यूज कर दिया ना पहले उन्होंने, फिर बाद में उन्होंने होम ऑफिस ने बोला कि ठीक है आप अपनी तरफ से विड्रॉ कर लो, हम आपको वीज़ा देते हैं।
ऑलराइट, वो किसकी
5 माह हो गए केस जमा कराए।
जी ठीक है,
लगता है शायद वो जानबूझ के डिले कर रहे हैं।
तो वो
जून की आखिरी डेट है
जी ठीक, वो किसकी वीजा
उनका वो इसलिए वेट कर रहे हैं क्योंकि हमने एमपीज ने भी लेटर लिखे हैं, सोलिसिटर ने भी लेटर लिखे हैं, वो जवाब तो देते हैं कि हम देख रहे हैं, हम करेंगे, कोर्ट का बहाना लगा रहे हैं। लेकिन 5 माह जिन लोगों ने उनके बाद भी अप्लाई किया, मेरे भाई के बाद, उनके वीजे भी लाके आ गए, तो वो यूके भी आप पहुंच के, लेकिन मेरे भाई का अभी तक फैल वो सिस्टर का पासपोर्ट ही वापस कर।
उसने क्लियरली लिखा है जी, उसने क्लियरली लिखा,
आप एडवाइस करेंगे
जी ठीक है, उसने क्लियरली लिखा है कि हम आपको वीजा दे देंगे। उसने जो कागज लिखा है ना, जब केस को विथड्रॉ किया गया था, तो उसने क्लियरली लिखा था कि हम आपको वीजा दे देंगे, क्लियरली लिखा है जी। आवाज आ रही है मेरी आपको? हेलो
हेलो
हेलो जी। जो होम ऑफिस ने जो कहा था ना कि आप केस को विथड्रॉ कर दो,
हाँ जी,
तो इसमें उसने क्लियरली लिखा है कि हम आपको वीजा देने वाले हैं।
सर जब उन्होंने लिखा ना विड्रॉ करने,
हाँ,
फिर उसके बाद उन्होंने फिर लेटर लिखा ना कि आप पासपोर्ट जमा कराएं।
ओके, तो
पासपोर्ट जमा कराने के ज़ाहिर है जब वो कहते हैं कि पासपोर्ट आप जमा कराएं,
ओके
तो
ठीक
उसका
है,
यही मतलब है
ठीक है,
कि आप को हम वीजा दे रहे हैं।
ऑलराइट, ओके। तो होम ऑफिस ने कुछ ऐसा तो नहीं किया ना कि हमने दोबारा कंसीडर किया, हम नहीं देंगे, ऐसी कुछ बात तो नहीं की ना अभी तक?
ऐसा कुछ नहीं है वो
जी समझ गया,
क्योंकि हमारे सोलिसिटर ने भी लेटर लिखे और एमपीज ने भी, उसमें उन्होंने कहीं मेंशन नहीं किया कि हम लिख कर रहे हैं या हम वीजा दे
ठीक है, ठीक है। द ओनली ऑप्शन आपके जी कोविड का बहाना कर रहे हैं ना, तो ठीक है सर। नॉर्मली ये जो विथड्रॉ करते हैं ना और दोबारा डिसीजन बनाते हैं, नॉर्मली उसको अबाउट 3 months 4 months निकल जाता है, वो अनयूजुअल नहीं है होम ऑफिस के लिए, वो वैसे भी बहुत स्लो है। सो 3 to 4 month डिले इतना अनयूजुअल नहीं है। सो आपने एमपी के थ्रू भी ट्राई कर लिया। द ओनली अदर ऑप्शन आपके लिए, और ये थोड़ा सा अर्ली है, द ओनली अदर ऑप्शन, इसके आप सोलिसिटर को कहें कि उसमें कोई प्री एक्शन प्रोटोकॉल लेटर भेज दो, ऐसा कुछ भेज दो, जुडिशियल रिव्यू का उसको थ्रेटन करो कि आपने ऐसी बात की थी, हमने विथड्रॉ किया और आप अभी वो डिसीजन के अगेंस्ट जा रहे हैं। यू कुड इवन थ्रेटन दैट। सो डिले के लिए उसको आप उसको थ्रेटन कर सकते हैं कि आपने बहुत डिले किया ये केस में। तो सो बेस्ट इज के यू ट्राइड द फर्स्ट थिंग विच इज़ के एमपी के थ्रू आपने ट्राई किया। अभी सेकंड थिंग आप ट्राई कर सकते हैं कि आप प्री एक्शन प्रोटोकॉल उसको भेजें और उसको कह सकते हैं कि आपका डिले का जो ये है ना, आफ्टर दिस मैटर वाज रिजॉल्व्ड, तो हम उसको चैलेंज करना चाहते हैं। सो द question that's been put is that there was an appeal which was ongoing. The appeal resulted in the matter being listed for a hearing before the tribunal. A day or so before the actual hearing, the Home Office decided that they were withdrawing the decision. So what you've got to understand here is that the Home Office was saying they were withdrawing the decision. They weren't granting the appeal, or they weren't agreeing to grant it. So when they withdraw the decision, generally speaking, in 99% of cases, it results in a visa being granted. Now here, after the Home Office withdrew the decision, 5 months have passed and the Home Office hasn't done anything. There's inaction on the part of the Home Office. The best thing is, at this stage, the first step they've taken already, which is to go through the MP. The only other step I can think of is that because this is no longer part of the appeal process, you could threaten them with judicial review. You could get your solicitor to write to them and serve a pre-action protocol letter on them, basically arguing that there is an inexcusable delay. The reality is there hasn't been sufficient delay for that to succeed. So you would never actually pursue it to actual judicial review before the tribunal because there hasn't been enough delay. Normally, when there's significant delay, you can challenge the delay by way of judicial review. Here, a delay of 4 or 5 months isn't sufficient, but as a tactic, as a strategy, it might be worth doing. It might prompt the Home Office to take some kind of action. So you've done the first thing, which is you've gone through the MP and you've got the MP to prompt them. Do that again, give it a month or so, do that again. The other option that you've got may not result in anything, but actually you're getting them to look at the file. And I think that's the idea here, is to serve a pre-action protocol letter on them. It may come to nothing, but you're actually getting them to look at this again. So it doesn't fall by the wayside. People don't forget about it. It's there. The MPs write in. There's a threat of judicial review. So these things are being looked at. Because in my experience, if there is a delay on their part and you don't do anything, there's a real danger that this never gets processed. 6 months, a year goes by and nothing happens. So in my experience, you have to remain proactive. They may be inactive, but you've got to remain proactive. You need to keep on pushing them. So getting matters pushed to the MP, pre-action protocol letter, a complaint, using the complaints procedure. Step by step, you should continue to push them, because what you don't want is that this is forgotten about, another 3 to 6 months go by and nothing happens. So you've got to remain proactive. The difficulty you have is you can't go back and have the tribunal open the case up because the appeal has been withdrawn. As far as I'm aware, you can't get this appeal reopened. So you've got to use these external methods, independent of the actual appeal that was going on before the tribunal. So that answers the question about the withdrawal of the appeal at the request of the Home Office. The first question that the caller put to us was in relation to an asylum appeal which has been refused. And I think the caller was concerned about some comments that the judge had made. And the caller explained briefly what the comments were. And I think they were along the lines of the judge saying it's important for us to maintain control of immigration, and that's an important factor. And that's one of the reasons why the appeal was dismissed. Now, I think this comment that's been made has probably been made based on what the Home Office position generally is, because the Home Office in a human rights appeal will obviously argue that the laws that they have in place and the restrictions are in place because there is a need to control immigration. And that's understandable. That's a legitimate aim that the Home Office has, to control immigration. And it's obviously to control immigration that you have immigration rules which people are required to satisfy. And I think what the judge was doing, and I haven't read the judgment, is the judge was saying that is the Home Office position, that, you know, there is a legitimate reason for refusing the application. The legitimate reason that's been put forward is a need to control immigration. And I think the judge was, in his or her decision, saying that that is the Home Office position as to why they were refusing your visa. It's the aim behind the refusal was obviously immigration control. And the judge, it looks like, was agreeing with what the Home Office said. That in itself, I can't see is objectionable. You know, obviously the position of the Home Office is going to be immigration control means that we can't grant a visa, you don't come within the scheme. Now, obviously what the judge then does, judge looks at your circumstances. The judge has to balance the argument being put forward by the Home Office, the need to control immigration, along with the arguments that you're putting forward, the length of time that you've lived in the UK. You might have a partner here, you might have children here who aren't British. So the judge has to balance the legitimate aid on the one side of the Home Office to control immigration, and obviously the points that you make as to the life that you've established in the UK. So I think what the judge was saying was agreeing that the Home Office case here was stronger. So on the face of it, I can't see a problem in itself for the judge to take that position. Now, obviously, if you're not happy with the judge's decision, you have the right to appeal against that to the upper tribunal. There's a whole process for that. You have 14 days to do that. So if you aren't happy with the decision, whether it's to do with the comments, you think the judge was biased, or there are other legal grounds that you can challenge the decision on, you would have 14 days to do that. So what I would suggest is get legal advice, get your lawyers to look at it, and if there are reasonable grounds for pursuing this, by all means submit an appeal against the judge's decision, you first of all ask permission from the first tier tribunal to appeal to the upper tribunal. If that refused, you then ask the upper tribunal directly for permission to appeal to the upper tribunal. There's an established mechanism in place for appealing against a first tier tribunal judge's decision. Hope that answers your question. Any follow-up questions, please do get in touch. We're taking a short break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please do contact me on the landline number which appears at the bottom of the screen. We've got some problems with our WhatsApp number at the moment, so please do contact me on the landline number 01924 231 083 and you'll be able to speak to me live on air. We've had a couple of questions in before, so let me just look at those questions. But by all means, to contact me, please do get in touch on the landline number. A rather long query that came in just before the break. Let me just read the question out, and then we'll look at how we can deal with that. So the question is this. I have been a victim of crime, criminal damage, within the grounds of a communal private estate that I live in. We have a management company that administers the groundworks, maintenance, etc. Understandable? They subcontract the CCTV management. The police are unable to arrest the perpetrator of the crime I was the victim of, as they require CCTV evidence. The CCTV contractor handed over to the police the incorrect footage and admitted they experienced technical errors which displayed the wrong dates, wrong times, etc. The problem is the footage is now lost. In short, the CCTV provided was wrong. And this has been confirmed by the police in writing. The question that's been put in this context is this. Can I pursue the CCTV contractor for negligence to recover compensation for repair costs less than £1,000, or should I pursue the building management company, or both? So this is a damage which has been caused. Not very clear from here what the actual damage was, but let's say the damage was to a car. And clearly, if there is CCTV coverage in the grounds, etc., it would have been picked up on the CCTV cameras. And most CCTV cameras operators would hold the footage for a limited period of time, whether it's 7 days, 30 days, etc. Here the problem seems to be this, that there is a crime that's been committed. It has been caught on CCTV, but as always, the police will request CCTV footage. Here the CCTV footage that has been handed over seems to be incorrect, wrong date, wrong time. And that's resulted in really the police not being able to catch the perpetrator or prosecute the perpetrator. I suppose by the time the error came to light, it was too late to put matters right. The CCTV footage had gone by then. As I understand it here, the case is that CCTV footage is kept for 30 days. So there's a problem, wrong footage is given to the police might sit on it, might take a bit of time to look at it. By the time they look at it, they realize it's wrong and they go back to the CCTV footage company or management company and it's all gone, it's deleted. So the correct footage now can't be retrieved. Therefore, the person who's committed the crime can't be caught and can't be prosecuted. And who's lost out, obviously, the victim is the person who sent the message in. Now, what can you do? Well, the police aren't going to be able to get the perpetrator anymore because there's no evidence. Question that's been put is, can you now pursue the CCTV contractor or the management company that looks after the grounds, etc.? So you can understand that where you've got certain areas, shared areas, it may be that the people who live there, they're paying a service charge for which they're getting a service. The service that the management company is providing is maybe groundwork, etc., along with that CCTV security, which is normally contracted out. And it's a CCTV company that's really messed up here. The problem here is you know, whether there is a claim in negligence or not. The difficulty that I see is that this loss seems to not be directly connected. So the loss that's occurred isn't directly connected to the actions of the management company or the CCTV company. It's too remote. The link is broken. The damage is caused by the criminal who's actually damaged the car or whatever else that they've done, or whatever other damage that they've caused. They are the people causing the damage, or that's the person who's caused the damage. I think it's then too far removed then to say that there's such a duty provided by the management company or the CCTV company, that the duty that they provide is such that if incorrect footage is provided, there's a breach of the duty and you're able to claim directly from them for the loss that's occurred because of the actions of a third party, the actions of a criminal. I think it's too indirect. The link isn't there. It's too remote. I think you would, because of that, I think you would struggle in negligence. The link is too tenuous there. I personally think the management company and the CCTV company would be able to get off the hook simply based on that they didn't owe that level of duty of care to you. Very unfortunate situation here, but because of the actions of the CCTV company, it looks like the person who caused the damage or whatever else that they did have managed to get away. So I think you're going to be in some difficulty pursuing these lot. I mean, look, you do say the claim is less than £1,000. If you did want to pursue a claim, it would be in the small claims court. So in one sense, you're not at risk of costs. If you were to be unsuccessful, you would simply have to pay the court fee in order to pursue a claim in the small claims court. And the small claims court fee for a claim worth £1,000 wouldn't be significant. It'd be something in the region of £100, £150, nothing more than that. So in terms of the risk to you, it is quite minimal. You're only losing a couple of £100 to pursue this as an initial fee. But again, it is time and effort on your part, and you do need to look at what's the likelihood of the claim being successful. In my view, it's unlikely that the claim would succeed. And therefore, my view is that, okay, if you really want to have a go, pay that £100, £150 and pursue it. But, you know, go in there knowing full well that it's unlikely that they would settle. Now, it may be that if it's a small sum, the CCTV company, the management company, may make some kind of offer to you simply to get rid of this litigation. So they may meet you halfway, etc. But if they were to dig their heels in and say, no, you know what, we're going to fight this, we're not going to roll over, I think before the court, it's likely that a claim in negligence on their part would fail. They've clearly been negligent, but the link between the loss and their negligence is too indirect. I think that's where the difficulty is. Because if you think about it, you know, in the city centre, you have councils which operate CCTV, so they record everything. So whenever there's a crime, if there's been a failure on the part of the CCTV operators who work on behalf of the council, who are monitoring what's going on, would you be able to, if you aren't able to pursue the criminal who's caused the damage, would you be able to pursue the CCTV operator? It's highly unlikely that the duty would extend that far. But thank you very much for your question. Interesting question. Let's see how that unfolds. Thank you very much for that. Okay. Now, as always, to contact me live, you can call on the landline number, which appears on the bottom of the screen. Alternatively, we have a slight difficulty with WhatsApp, but if you do send your questions in, if I can't deal with them today, I will try and deal with them next week. Now, one of the questions that a caller who called in and asked was in relation to spouse visas. And the particular question is that in relation to a spouse application which is being made from abroad, what if the spouse who is abroad is unable to produce certain documents? such as a TB test certificate or an English certificate, because there is a lockdown in the area where they live, is it still possible to make a spouse application to come to the United Kingdom? Now, that's a very common problem at the moment, that with immigration applications, there is some difficulty in meeting the requirements of the immigration rules, because sometimes it's difficult to get hold of certain documents which need to be submitted. And here the question that's been put is that if, because of the current lockdown in the home country where the spouse is, if it's not possible to recover certain documents or obtain certain documents, is it possible really to be exempted from that requirement to produce that document? For example, here, the way the question's been put, if there's a requirement to produce an English certificate when a spouse is being sponsored to come here, or if there's a requirement to produce a TB test certificate when you're sponsoring somebody to come here, and if you don't have it, can you be exempt? Because the reason for not having it is that there's a lockdown. Can you be exempt? Now, the Home Office has said that in limited circumstances, we will apply an exemption and we will exempt you from certain documents. Now, specifically in relation to the English certificate, they have said that if you are unable to do the English test because the test centre is closed, or you are unable to get to the test centre because the area where you are in is locked down, then we are prepared to exempt you from the English requirement. So specifically in relation to the English test, the Home Office has said, if you can demonstrate these things, we will exempt you. There isn't anything specific for the TB test, but my view is this, that look, if you are struggling, submit the application and explain why you're struggling. It may be that by the time the Home Office looks at the application, it is possible for you to obtain the TB test and the English test. So it may be that the Home Office will turn around at that stage and say to you, look, you know what? We understand when you applied, you couldn't get these documents, but we're now giving you more time to get those documents. The benefit of that is this, that at least you've got your application in, it's been progressed, and you get to the end stage where it's all been reviewed and they've looked at the missing documents. They may agree. They may simply say, we are prepared to exempt you from the requirement. You can't get a TB test, you can't get an English test, we'll exempt you from that. Or worst case scenario, 3 months down the line, they've looked at it and they'll say to you, can you now obtain it? And you'll need to explain to them whether it can be obtained or it can't be obtained. So my view is that, look, if there is a real difficulty, then carry on and then do, I think, submit the application and explain what the situation is. There is a good chance in the current circumstances that the application could succeed. We're taking a short break. We'll be back in the next couple of minutes and we'll pick up where we are then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen, 01924 231 083. Your call will be put through to me live in the studio and I'll be able to speak to you live and advise you on any matters that you need advice on, any legal matters. We have slight difficulties with our WhatsApp today, so it might be that some of your messages that you're sending through might not be getting through. But if you have sent messages today and I haven't been able to look at them, what I will do is try and answer those questions next week and hopefully those issues will be resolved. But by all means, to speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. Now, what might be useful is for me to just update our viewers on what the current position is in terms of COVID-19 and how it affects immigration, the Home Office, the tribunal system, etc. In practice, immigration lawyers are currently frequently being asked about visas, visa extensions, and what's going on in terms of processing times, etc. Now, what the Home Office has done, very, very helpful. The Home Office has a dedicated page dealing with immigration issues relating to COVID-19. And what the Home Office has done throughout the last year is, very helpfully, is on that page, they've explained what they're doing in order to deal with any difficulties which have arisen. So if I give you some examples, the Home Office breaks it all down, saying, look, if you're in the UK and you can't leave the UK because your flights have been cancelled, you're in danger of your visa expiring, what you need to do for that. If you want to switch into another visa category, normally you'd have to leave the UK. Are you allowed to do that in the UK? So the Home Office deals with that. If you don't want to go back because of COVID-19 and the lockdown in your country, can you apply from within the UK? The Home Office deals with that issue as well. The Home Office then deals with applications that have been made from abroad. If applications have been successful, there is a delay in you being able to come to the UK, and that visa that you've been given, that visa is about to come to an end. What do you then do in that situation? Or, for example, you're unable to obtain documents in support of your visa application. What can you do in that situation? Or alternatively, let's look at the financial requirements which need to be met for spouse applications, etc. What if you can't meet the financial requirements because you've been out of work or your income has dropped? What happens as a result of that? So there's a whole host of different types of issues which have arisen in the immigration sector because of COVID-19 and the lockdown that we've had in this country and other countries as well. So it has a real impact on immigration matters. So if you want to keep abreast of what's going on, if you go onto the Home Office website, if you look at the updates page, you'll be able to go onto the page which explains everything that the Home Office is doing to deal with the problems which have come to light. Now, what I want to focus on is an area which in practice is quite something that's coming up quite regularly. It's causing real problems. And the issue is this. Obviously, over the last few months, people, as always, have been coming to the UK on visit visas. A lot of people have come from countries such as India, Pakistan, Bangladesh, Dubai, etc. Now, as our viewers will be aware, in the last couple of months, these countries have gone onto the red list. So we understand what the red list is. If we from here were to travel to these countries, it would be difficult. When we come back, we'd have to quarantine in a hotel. That's all understood. But there is another problem with that, which is if you've come from a country which is on the red list, let's take, for example, UAE. You live in Dubai, you've come here on a visit visa, on a work visa, your visa is about to come to an end. The difficulty is that a lot of red list countries have had flights which are cancelled. So, okay, you might be easy to get to Dubai, but certain other countries, India, Pakistan, Bangladesh, etc., it's difficult to get flights to those countries because airlines are regularly cancelling the flights. So in my experience, what's happened is that in very limited circumstances, you might be able to get a flight from Heathrow, but flights from other airports, Manchester, Birmingham, etc., they've been cancelled. It's very difficult to fly out to these countries. You might book a ticket to go from Heathrow, and at the last minute, the operator cancels the flight. Now, the Home Office is aware of that a lot of these countries are on the red list, which means that, fair enough, you'll have to quarantine if you come from those countries, but there's a difficulty leaving the country to go back. Let's say, for example, your visa expires on the 30th of June. You need to leave the UK to go back to your home country. It's on the red list. The flights have been cancelled. It's a common problem which is coming up regularly. What can you do in this situation? Obviously, you don't want to become an overstayer. There are severe problems which becoming an overstayer. It's illegal to overstay in the United Kingdom. If you leave the country after you've overstayed, you might experience difficulties in coming back to the UK. You may be banned for a year or so from coming back to the UK. So that's the particular difficulty that you may face. So what the Home Office has said is, look, if you're in a situation where you cannot travel back to your home country, your visa is about to expire, then all you need to do is email the Home Office and ask for what they called exceptional assurance. So that's what you're asking for, exceptional assurance. You don't have to complete an online form. You don't need to pay a fee. It's not complex. You are basically emailing the Home Office on the email address that's been provided. You're providing the Home Office with limited information, such as your name, your date of birth, your visa number, the reason why you can't travel, what attempts you've made to travel. So you do all this, you provide this information to the Home Office, and the Home Office will then tell you whether they are prepared to grant you exceptional assurance or not. So what exceptional assurance normally is, that they would email you back in a letter form telling you that we are giving you an extra month in the United Kingdom. So although your visa expires on the 30th of June, you're getting an extra month. That may take you to the 30th of July. So you're not overstaying after your visa expires. And that's really helpful. Let's take our next call. Hello, Assalamu alaikum. Hello.
Hello?
Hello, Assalamu alaikum.
Yeah, I want to talk to Ilyas.
It is Ilyas. You're speaking to me live. What's your question?
I'm talking to... Hello?
Hi, I can hear you. You are live on air. So please feel free to ask your question.
Sorry, my children is there, so I can't. I have a question.
Okay.
Hello?
Hello, hi, I can hear you. Yes, carry on, please.
Yeah, actually, I have a question about, I have a son, 7-year-old.
Okay.
So, can I, if there's still same rule for 7 year, I can put the both application.
Okay. Was he born?
Family settlement.
Okay. Was he born in the United Kingdom?
Yeah.
Okay, and he's 7 years old at the moment.
He's 6, so he's going to be 7 next month.
Okay.
Next year.
Oh, next year. Okay. All right. And in terms of, is the application for yourself? Is it? Have you overstayed in the United Kingdom?
Oh yeah.
Okay.
I'm overstayed.
Overstayed in the United Kingdom. Okay. So what you can do is don't put the application in before he turns 7. So you must wait until he becomes 7 years old.
Until he becomes 7, yeah.
Yeah, and then put the application in. So that's the first thing. The second thing is, you might be able to apply for a fee exemption. You might be able to apply for, because if you've got no money coming in, so the second thing you need to look at is whether you qualify for a fee exemption. So normally there's a fee of about 2,700 that you pay, application fee, NHS fee. You might want to consider applying for a fee exemption. At the moment, because of COVID-19, they are granting free exemptions to people in your situation. I don't know when he turns 7 whether that policy will still apply or not, but you could still try for the fee exemption. So you could try that. Now, there is no guarantee that even if your child turns 7 that they will grant the visa. But the good thing is this: if they were to refuse the visa, they will grant you a right of appeal. So if the application is refused, they don't have to grant it. But if they do refuse it, if you've made the application after your son is 7, you do get a right of appeal, and the judge at least looks at the case later on. There you've got a better chance of succeeding. So what I would do is, once your son turns 7, I would submit the application at that stage. Does that answer your question? I'm not sure whether we've got the caller there. I think the caller's gone. But in brief, you have to adopt some kind of plan, in my experience, with these applications. So you need some kind of strategy. What I would do is, once the child reaches the age of 7, you submit the application. If it's granted, fantastic. You're successful at that stage. If it's unsuccessful, it goes to the tribunal. There's a good chance the tribunal may grant it. If it's unsuccessful at the tribunal stage, you still have another chance, which is a child that's born in the UK. Once that child reaches the age of 10, then the child becomes eligible to apply for a British passport, a British nationality. Once the child becomes a British national, at that stage, because you have a child that is British, you're more or less guaranteed to be granted leave to remain on the basis of that child. So you adopt a particular approach. Wait till the child is 7, apply for a fee exemption, apply for the full application based on your child being 7. If you're successful, fantastic. If not, appeal against the decision. If you're successful, fantastic at that stage. If not, once the child reaches the age of 10, bearing in mind this is a child who was born in the UK, the child would then qualify for British nationality, register the child as British at that stage, and then once the child's British, you would be able to apply again based on your child being British. So you adopt that kind of strategy, that kind of plan with this particular application. Hope that answers that question. It's a matter where you might need to take legal advice in order to ensure that all the correct forms are completed, correct documentary evidence is submitted. If you're not clear about anything, please do give us a ring. We're going to be back next week at 7 o'clock. So, you know, it gives you a week or so to think about what we need to do. Not sure, give me a ring next week and we can look at this in greater detail at that stage. That brings us to the end of the show. We'll be back next week on Tuesday at 8 o'clock.